Hello everyone, my name is Katie Binkley and I'm a lead staff attorney with Veterans Legal Institute. Veterans Legal Institute is a nonprofit law firm that provides free legal assistance to homeless, low-income, and elderly veterans. We aim to provide pro bono legal assistance to veterans in order to connect them with life-saving benefits. In today's video, we're going to talk about how to triage a family law case. Now, it's important to mention that this isn't legal advice in this video, but instead I'm going to be providing some general information to you. So let's begin. Attorneys are perfectionists, and I say that without judgment, as I am one. In order to assess a family law case, attorneys commonly like to start by looking at the entire court's record of orders, any minute order or transcript that we can get our hands on, and in a best case scenario, we will get to review the tax returns of all parties for at least the past 2 years prior to meeting with the client. However, when you're working with a legal aid client, this is a luxury that you just don't have as an attorney. Your first instinct might be to send them on their way, ask them to collect their court documents and come back to you when they've been able to do so. However, I would encourage you not to do this for the following reasons. The first, the client might have taken off work to make the appointment with you. Second, the client probably arranged childcare to have the time to speak with you uninterrupted. Third, the client might not even have access to their court documents. Maybe they've been battling homelessness and their court documents are in a storage unit which they can't even afford to visit. Or fourth, the client might have a mental health condition or disability which limits their capability to participate in their case in a meaningful way. Working with a vulnerable veteran population, this is a common occurrence that we see at Veterans Legal Institute. Many veterans suffer from conditions like post-traumatic stress disorder or a traumatic brain injury, which could limit their opportunity to participate in their case. It's a conscious exercise to put aside our structure of our workflow as attorneys in order to meet these legal aid clients where they are and accommodate them. And none of this is to say that professionalism and order go out the window when working with a legal aid client. It's an act of empathy and respect to provide as good of a service as you can with the limited information that you have at that time. So now I'm going to make some suggestions as to how you can triage a family law case with a legal aid client. Suggestion number 1, search the case online. Depending on what county the case is in, you can find varying levels of information on that case based on the court's register of actions. Depending on what county, you might be able to search with a case number or you might be able to search using someone's name. In Orange County, you can search for a client's name with the payment of a small fee. So what if your client doesn't know their case number? This might be a situation where you use a paid feature in order to search that client's name and obtain their case information. The cost for this is normally about $2 to $3. So you can determine on a case-by-case basis whether that's appropriate. A free option would be to have the client contact the courthouse, provide his or her name, and get their court case number from the court clerk. Now, it's important to note that the court will only release this information to a named party to the case. So even if you want to try to call and get that court information for the client, the court will not release that information to you. Once you have that information, search the case online to get a general information of where the client is in their case. Maybe they have a hearing upcoming. Maybe you can see that that client needs to file a proof of service. Maybe they've been served with a motion and they've yet to file a responsive declaration. Seeing where a case is at on the register of actions can give the client a sense of where they are at in this case, which makes it a lot more of a bearable problem to have. The problem with paternity cases. As family law attorneys are aware, when there is a parentage action, meaning that the parents of the child were not married at the time of the birth, their court case is sealed from public access. In this case, our hands are actually tied unless we have some type of information. If you're in this situation with a legal aid client, try giving them advice on how to obtain those court documents. They can purchase their court documents by going to the courthouse or ordering copies online. And the client can ask that a fee waiver be applied to their printing costs. Suggestion number 2, protect the client from adverse action by preparing judicial counsel forms. Being in family court is the most common occurrence for your average everyday person to interact with the family court system, or at least that's the case in this highly unscientific study that I've concluded. While you may never breach a $1 million contract or become catastrophically injured, statistically you're pretty likely to get a divorce or need an order for custody or child support. We attorneys are so used to being in court all the time and filing lawsuits that we can be a bit jaded and assume it's easy. But this is not the case for your average person. If we were representing that client as the attorney of record, our first action would be to get a response filed in the case. Share that opportunity with your legal aid client by advising them of the importance of submitting a response. This could either protect them from a default judgment or gives the court an opportunity to hear their arguments before the hearing begins. If you help a client complete an FL 120, you protect them from a default judgment which could be adverse to them. If you help a client complete an FL 320, you're helping that client get his or her arguments represented to a judge before they even appear in the case. And most importantly, if you help a client complete and file an FL 150, you ensure that the court has the most accurate information when making child support orders, which can avoid the risk of unattainable payments or unnecessary arrearages. Suggestion number 3. Help the client request a hearing. A client might come to you and vent about his or her court orders are outdated and no longer practicable for the family. Teach that client about what it means to file a request for order. You can print off the documents in your office and help them complete it out. There are attorneys at the Self-Help Center who can review those documents for the client prior to filing. While you may not be able to assist in the outcome of that hearing or ensure a positive result, you're giving that veteran access to justice by letting them have the opportunity to have their day in court and go before a judge and fight for what they need. Number 4, help the client prepare for a hearing. Imagine walking into an intimidating courtroom without knowing the procedures and knowing that your time with your children hangs in the balance. That's not necessarily a confidence boost before going into your day in court. Give a client the confidence to appear on their own by letting them know what to expect, where to stand, who will be in the courtroom, and how the general flow of the day is going to happen. Information is power, and power gives the client the strength to advocate for themselves. Number 5, call up opposing counsel. It can be difficult for counsel to communicate with self-represented parties. I personally find it easier to work with another attorney on the case, as we know the general law that governs the dispute and we remain professional and cordial at all times without letting emotion cloud our judgment. Giving a call to opposing counsel can help you determine where in the case the client is at. There might be an outstanding proposed order or judgment which you could evaluate with that client and help them resolve the case simply. If you take this option, it's a professional courtesy to let opposing counsel know your limited role in the case. Be clear that you're not the attorney of record, but that you're volunteering your services and helping that client with their case. They may ask that you sign some type of authorization with the client's permission to speak with them. And if that's the case when you're volunteering with one of our VLI clients, just reach out to us and VLI can provide those proper forms for you. Suggestion number 6. Write a supplemental declaration with the client. Declarations are the opportunity for a client to really tell their side of the story in a way that you just can't do by checking boxes on judicial counsel forms. There's also the reality of packed judicial calendars, and a judge might not have time to hear substantive arguments, at least to the extent that the client might feel comfortable with. Not having time to hear a client's arguments in court can make that client left feeling hurt, confused, and unheard. Help that client feel like they can share their story by preparing a supplemental declaration to file before the hearing. As attorneys, we already expect a limited time frame, so we know how to organize our arguments and present the most compelling facts with the limited time that we have. Your expertise in organizing arguments in a concise fashion is a huge benefit to a pro per client. How many times have you been speaking with a client about their custody case and they tell you it all happened 15 years ago? We as attorneys know that is not a good way to start a declaration. Help a pro per client organize their arguments in a brief and concise supplemental declaration. Start with 1, what is the court's order that's current in place? 2, what is that client looking for? And 3, why is that in the best interest of the children? In preparing a supplemental declaration, you can use the MC030 Judicial Counsel form. You can also write a declaration on pleading paper, or if it's attached to pleadings, you can write it on a standard Word document and just attach it to what the document is already going to file. By submitting a supplemental declaration with the client, you've increased the odds that the judge hearing the case actually has the time to hear all of the arguments of the case in a way that they might not have been able to if the client submitted a 20-page soliloquy they wrote on their own. If any of these opportunities sound like a fun and exciting challenge to you as an attorney or a great way to give back, please reach out to us at Veterans Legal Institute for volunteer opportunities. You can visit our website at www.vetslegal.org. Thank you.